When we get contacted by company directors who are under pressure, more often than not it's the Inland Revenue, HMRC, that are moving towards formal procedures, such as they might have issued a winding up petition.
Yes.
In that sort of scenario, if someone rings in, what typically would you run through with them as to what we might be able to do?
Well, I think we need to understand clearly the financial performance of the business and what its potential is to generate income from its trading or from its assets, in that we're looking to be able to liaise with HMRC and make offers to them to either head off their enforcement pre-insolvency or indeed deal with the winding up petition if it occurs. And you probably remember that even if a winding up petition is already in place, we can go to the court and seek a validation order, so that if the company has got money in the bank which it could otherwise use to settle its debts or deal with its creditors, the court can be asked for permission for that money to be released if the money has been held as a result of the winding up petition having been issued. Beyond that, if there are some doubts about the ability to trade forward with precisely the current company model or the type of business or structure or size of business that is involved, then it might be possible to think about an alternative insolvency process, perhaps petitioning for administration or CVA, which would then allow the business to go forward as a different structure, but avoid compulsory winding up and the consequences of that.
In terms of cost, I'm sure the directors will be worrying about whether they can afford our advice and how much those processes would cost. What have you got to say on that?
Well, I think in the initial contact with them, initial advice, telephone call or meeting is going to be a free scenario, because both parties need to familiarise themselves with the situation, and that's a free exercise. Beyond that, if we're needing to provide ongoing advice, perhaps with a view to avoiding informal insolvency altogether, that can be done on a fixed fee basis. Beyond that, if we are looking at validation orders or other insolvency processes, that would have to be assessed on a case-by-case basis.
But is there sort of scope for deferring those costs?
Yes, there is, because the costs would form part of any future insolvency process. There is clearly a high element of the creditors having to agree them in any case, and they would come out of the ongoing pot from asset realisations in the case, rather than there be a need for the business owner to find money up front to get the assistance that he needs.
Okay. And so if you're a director now with a winding up petition on you, what would be your sort of best advice for them to do next?
Well, best advice clearly is to seek qualified advice on their situation, because the scenario which almost guarantees a problem that is extremely difficult to get out of is if you do nothing.
And just to sort of emphasise the word qualified advice, what are you sort of driving at there?
Well, I think you need to speak to a licensed insolvency practitioner rather than any other expert who holds themselves out to have that advice, that expertise, but may not actually be licensed and have the experience that is needed across all trades and over a long period of time.
Okay, that's been very helpful.
Thank you.